Hello, everyone. Hope everyone is having a nice evening. I call the Select Board meeting to order tonight, Tuesday, July 11th at 8:09 p.m. A motion to open the meeting.
So moved.
Second.
All in favor?
Aye.
Aye.
And I vote aye as well. Roll call, Mr. Gito.
I'm here.
Great. Vice Chair Cavey?
Present.
Mr. Carrara?
Here.
Mr. McCrisky is out, and I am here. I ask that you stand so we can salute our flag. In accordance with Governor Baker's declaration of June 16, 2021, granting certain pandemic-related authorizations related to public board and town meetings and recently extended until March 31, 2025, this meeting will be conducted both in person and virtually via Google Meets. The meeting will be recorded by SMAC Cable Television and broadcast live and may be live streamed at www.stoughtontv.org. A recording of the meeting, transcript, or other comprehensive record of the proceeding will be posted on the town's website and or SMAC as soon as possible after the meeting if live broadcast or live streaming is unsuccessful. Times are approximate and items may be taken out of order at the chair's discretion. First, before we open or continue our public hearing, Mr. Carrera, did you have comment?
Yes, Madam Chairman. I'm always the one who brings the sadness, I guess, but it has to be recognized. On Saturday, I was able to be told we lost a Stoughton icon, Larry Barrett, as most of the people know him. Larry worked for the Stoughton Public Works Department for 43 years. He came from a truck driver to a shovel operator, which most people like me understand, but some other people would call it something else, but it was a proud thing to become a shovel operator. Then he aspired to become assistant superintendent and finally the top superintendent of public works. But I know by the little smile that Larry always had when he got back in the seat of a truck or behind the levers of a machine, he was at his happiest. Larry was very instrumental in many town projects from start to success. I could go on for many hours with all the projects that he's did, but the main thing is we should thank Larry and his family for his service and the success of the others that have followed him. Larry wasn't all business. He loved his wife, children, and most of all his grandchildren. So, from the Board of Selectmen to his wife, Corey, his daughters, Suzanne Barrett and her husband, J.B., who is now the town administrator in Avon, Sandra Barrett, who is a detective at the Stoughton Police Department, and his daughter, Stacy Conley, and her husband, Stephen. They got many grandchildren. So to his family, our deepest sympathies and regrets for the loss of such a decent man, and we, the Board of Selectmen, will miss him and the residents that knew him. God bless, and may he rest in peace. So that's our first. That's a tough one for me. I've known Larry most of my life. Since, it was always a big thing to see him. Now we have another gentleman who I don't know if many people today would know him since he's retired in 2004, was Ed Jamison. He was a man not to be missed. He was as kind as his 6'6" height. Devoted husband to his late wife Diane and his children. He is survived by his daughter Kerry Fix and her husband James. Ed gave his all for the 22 years that he served as an officer on the Stoughton Police Department. His size and uniform was something more than awesome, but he had that take care gentleness to him. He always helped the elderly, and then he'd give the young kids let's get up and do something. So to Ed Jamison, his friends, his daughter, from the Board of Selectmen, our deepest sympathies as he enters into his past now. And that's all I got to say. A moment of silence for both parties, please. Thank you, Deborah.
Thank you very much for those kind words. With greatest, deepest sympathy to the friends and family. Now to Vice Chair Cavey, would you like to open the continuation of our public hearing from July 5th, and then we will transition over to Attorney Winter so he could update us or provide us clarity on the order of operations and some other directions regarding this hearing.
Thank you, Madam Chair. I move that we continue the public hearing from July 5th, pursuant to Mass General Law, Chapter 140, Section 157, to hear and consider a request for a dangerous dog hearing dated June 14th, 2023, filed by the Stoughton Animal Control Officer concerning 2 dogs harbored at 408 Technology Drive, apartment number 5420, and owned by Rosalina D'Souza Geller.
Second.
All in favor?
Aye.
And I vote aye as well. Thank you. Attorney Winter.
Thank you, Madam Chair, and good evening, members of the board. I'd like to begin with just a few words on where we're at in this process and what you can expect this evening. So on the 5th of July, we opened this hearing, and you heard some introductory comments from myself. You heard testimony from Detective Barber and ACO Carlos. We heard answers to the board's questions. Attorney Moriarty was present with his client and had an opportunity to ask them questions as well. They are here this evening, and so just because we finished sort of the direct questioning on them, they're here to answer any further questions the board might have. We don't need to stand on ceremony here, so if anything comes up during the proceedings this evening and that leads you to want to have further questions of them, you should feel free. And we'll call them up and we'll ask those questions and hopefully get answers. What I expect this evening, since we've heard from the town's witnesses already, is that we'll begin with Attorney Moriarty, who can present his case however he sees fit. He may wish to make a statement. He may wish to have his client speak. However he chooses to proceed, you, the board members, are more than welcome to ask questions of him. He's obviously not a witness, he's counsel, but you can ask him questions. And if he is willing to have his client answer any questions, you'll be able to ask questions of her. Next up, I believe that on the 5th we had Ms. Cardula, who I believe, if I'm not mistaken, is with us virtually here this evening. Yes, I still see her up there, her tile up there. And I also see Christine Wilson up there. So after Attorney Moriarty is ready to step down, we could hear from what I'm going to say qualified members of the public. So as we mentioned earlier, even though this hearing occurs in public, it's not a public hearing. So I'll ask if anyone wants to speak other than Ms. Geller that they introduce themselves and their connection to this case, so we know why they have either firsthand knowledge or direct testimony as to the matter before the board. And after that's concluded, and you as a board decide that the evidence is done, the evidentiary portion is done, I'll ask you to close the public hearing. And at that point, it'll come back to the board and we'll start into deliberations, and I'll guide you through that process. So that's all I'll say for now, and if you're so inclined, we can begin with Attorney Moriarty.
Hey, I just want to let you know I'm Christine Wilson. I would like to speak.
I'm sorry, Christine, did you, there was some static. Can you repeat what you
Sorry,
said?
it's probably my finger on the phone. I was just wondering if I could speak at some point today.
Oh,
Thank you.
Absolutely, absolutely.
Thank you.
Thank you.
Good evening, Madam Chairperson and Board. Attorney John Moriarty for Ms. Geller, the dog owner.
Sir, would you mind moving the microphone closer to you?
I'm sorry, dog owners. Is that picked up? Okay, great. I don't know if you want to finish with, I guess, the case in chief for the town and do the testimony for the witness first before you go to Ms. Geller, or do you want to take it out of order? That's fine with me.
Madam Chair, if I could
Yes, Attorney Wood.
respond to that. Because the two parties online are not municipal officials or parties that I've subpoenaed, I'm happy to let you go next.
Sure.
And then we'll take them as interested parties at the end.
Sure.
If that's okay with the chair and the board.
Yes, please.
Wonderful. So where we left off last time, we ended with some additional submissions by the town, specifically the dog officer, with a behavioral report and sort of an updated summary. So that being said, I've reviewed the materials. I don't know if this board has questions on them. I will rest on what has been submitted. I defer to the dog officer. Her opinions are observational. So I have no further questions on that unless this board chooses to inquire. On behalf of Ms. Geller, I've spoken to Ms. Geller. She's obviously beside me right now. She's stressed to me this is a very difficult situation for her, and speaking about it, it gets her very excited to the point where I don't think it would be well to communicate. So she has asked me and agreed that I sort of convey some sentiment about what had happened on her behalf. She is truly apologetic for what had happened. She does believe that if she had just left the situation and returned back home with her dogs, this would not have happened. The curse on that was that she felt unsafe for herself, and you've been submitted all the materials on behalf of the dog owners. So she felt an obligation to stay and remain until officers arrived to respond to her request for help. And repeatedly her saying over and over again, I need help, I need help. She was able to go down and see her dogs last week. She did observe a scar. She was unable to get a picture. She didn't want to startle the dogs. She was able to bring a blanket. She was able to spend some time and comfort the dogs. In my conversations with the dog officer, after she left, it was, it was a little, not traumatic for the dogs, but they were sad. They were whimpering. To this day, I still don't know of any incident where Dakota, the dog, one dog in question, has been violent or aggressive outside of let's say since it has been in custody. And also the testimony, I will remind this board, there is no testimony that Dakota, in fact, had bit someone. So those things being said, I think the best way to proceed is that if this board has questions, Ms. Geller would be happy to answer them and address you directly. She wanted to convey to me on her behalf, obviously, she does not want to see any of her dogs declared a dangerous dog, subject to the ramifications or the penalties which this board is empowered to pursue, which would obviously be in order to put the dogs down. She is willing to make remediations according to the statute, and I think they're pretty strong remediations. She's willing to do just about anything. She's willing to have her dogs consult a dog psychiatrist and do a behavioral report. She's willing to have her dogs muzzled. She's willing to have her dogs issued an order that they not be walked together. And just about any other order that you're empowered to give under the statute. I will reserve the rest for closing. I will also say that she has already made arrangements to relocate physically her dwelling to a larger space and to a different accommodation outside of this town. She understands the importance, for her dogs to matriculate back into or include some more socialization, and she's willing to include that in any sort of accommodation for the remediation order that this board may see deem fit. And that would include sessions and an identified and clear number of sessions with a dog trainer. I think it's important to remember, although this board cannot consider breed, and I understand that, and it's largely on the dog itself and its actions, that we're dealing with dogs that are 1 year old. And these are not mature dogs. These are dogs that have not had a long time to walk this planet and, in Ms. Geller's case, interact with other dogs on a regular basis. She's always kept her dogs with herself and walked them on their own, and they've always been in a dog park. I think it's important to remember, if these were older dogs, more mature dogs, set in their ways, I think it would be a little bit of a different story. Although you can't take breed in consideration, you can take age and socialization. So that being said, I will open it up to this board to have any questions from Ms. Geller to reply and respond to regarding the incidents of that afternoon, what had happened at the dog park, how she had controlled her dogs, her actions, what she had done, what she tried to do, and what had happened.
Are there any questions from the Select Board to Mrs. Geller?
Yeah, I have a few.
Vice Chair Cave?
So, Ms. Geller, I know this is an emotional experience for you. It would be for me as well if I was in your place. I definitely sympathize with it. If you're not able to answer these questions, if some of these might be things your attorney would know the answers to, feel free to pass that on to the responsibility to answer it on to him. First question is: have the dogs been with any formal training? Have they performed any sort of formal training?
No, sir.
Okay. Let's see. So right now the dogs are both close to 50 pounds apiece.
Maverick is 60 pounds.
Okay, Maverick is 60.
Coda is 47.
47. Okay. The current remediation that you're proposing is having a psychologist available for the dogs, not walking them together. If I understood you correctly, also a trainer. Was that part of what was in there? And the fourth is that given some of the paperwork that you provided, it looks like there might be. This is more of a question than anything, but there might be an issue with your association's lease agreements, where because of this, they're asking the dogs not be there anymore, and you're talking about leaving the town in order to accommodate their needs. Is that correct?
Yes.
Okay. Thank you very much.
Thank you.
Thank you very much, Vice Chair KV. Mr. Gito or Mr. Carrera, did you have any questions? Okay, Mr. Carrera.
This is more of a statement that might not go there, but it might have to go to our attorney. This is a legal case before us, and if we allow her to take the dogs and say, go to another town, and there's another attack within a certain, pretty quick or whatever, how liable are we that we didn't do what we should have done here? Could that fall back on us in a way?
So let me answer that directly. I think you should continue this process to the end, no matter what, and make what order you think is appropriate. That's what the statute requires. That's your duty under the law. Now, what happens next, nobody can predict, of course. If the dogs are in Stoughton and there's an incident, well, you're going to have to fall back on your order, right? And we'll seek to determine whether it was complied with or there was a violation. And certain liability might flow from that, not to the town. This is a discretionary order, and you're essentially acting in a quasi-judicial capacity. You're judges here. And so you're going to use your discretion to fashion an order, and that's not going to give rise to liability just because something may or may not happen in the future. Now, even less so if it's in another community. There's a question, the statute does not address this. It's completely silent. What happens to our order if the dogs that are the subject of the order are in another community? There's no sort of dog registry, system. And so your order is a valid, legally enforceable order in Stoughton. I don't know what a hypothetical community somewhere else, what they might do with that. The law provides that the owner, if they sell or gift the dogs away, are supposed to advise someone that the order exists. But again, we're not going to be part of that, so we might not see that. So I think the one thing that we do have control over is the one thing that you should finish doing this evening or at the end of this process, which is issue the order you think best protects public health, safety, and welfare based on the evidence you've heard.
Thank you very much for your question and response. Mr. Gito.
Let me start by saying there's no one here who really wishes to be here. I think there's everyone involved in the process is probably a victim in this case. But this is a serious matter, and I guess, would you be willing to do the things that are required in Chapter 140, Section 155 and 157, like confining the dog to your own premises? When it's off the premises, to muzzle the dog and to make sure that it's on a tether that's has 300 pounds tensile strength and is 3 feet long. Have a $100,000 insurance policy. And know that you can't transfer ownership of that dog without informing the person that you might be transferring it to, that the dog is a dangerous dog?
Am I supposed to answer now? I didn't know when
You
to
may
answer.
answer.
Oh, okay, I'm sorry. Yes, my insurance for the dogs, for my rental insurance, I have increased it. And I thought that even if you move out of town.
Would you move that microphone closer to you,
Oh, I'm
please?
sorry, sir. Even if you move out of town, doesn't the order still stay with the dogs until they, get old and pass away? Or it's only in Stoughton? So if I go to, say, for Avon, isn't it the same order in Avon?
As far as I know, it is.
Right, so
I
whatever.
think this is a state statute.
Oh,
And so you are required to continue to adhere to the terms that the board would provide.
yes.
And if you don't, you would pay a $500 fine or 60 days in jail. for the first offense, and for subsequent offenses it'd be $1,000, and 90 days, up to 90 days. And if I were to write something that said what you were going to do, I would make sure that you had to report annually to the Stoughton Police Department or the Stoughton Board of Selectmen where you were living and where your dogs were. So there'd be no question about the fact that those dogs were under control. So.
Oh, can I'm sorry, I don't know when
Please,
to
that's,
act.
I'm just laying out what I see in the law, and what I would suggest be done if those dogs were to remain around.
Yes, I'm willing to do anything, sir. I will, anything. They're just babies, so I don't want them to go down.
I do not wish to be cruel by asking these questions, but we have another person who has very serious problems because of your dog or dogs. I've never confronted a dog, and I'm a pretty old guy, that did what your dog or dogs did. And I would not be at all pleased to have that happen to me.
Mr. Gito, did you have any other questions at this time?
No.
Thank you very much. Mrs. Geller, I'm very sympathetic to your emotions. I understand completely. We have a decision that I'm trying to personally better understand whether to dismiss the case, declare the dog a nuisance or the dogs a nuisance, or dangerous dogs. We heard the report, the police report, we read it and heard it verbally. From your own words, if you are able, can you tell us what happened prior to the police officers arriving, if you care to add any context? I'm trying to really understand from beginning to end of when you first arrived at the dog park before the police officers arrived.
Okay.
And take your time, please.
Okay.
Yes.
That day I got home, I go to the dog park because Dakota, she can only do her business in the dog park. Maverick can go anywhere, but Dakota can't. So that's why I always go to the dog park. I put them in the dog park, they were fine until the owner of Chester came. He got out of the car. Maverick's always been a barker. She always barked since the day I got her. Dakota is more calm. Not a barker unless she hears noise. When Maverick saw, sometimes when she sees dogs, she bites at the fence, but she doesn't do anything. That's something that she does, and I try to stop her from doing. And he said that is dog fence aggression. Let me bring my dog inside, and if your dog bites my dog, I won't do anything about it. And I said, what? I said, please don't. I said, please let me leash my dogs so I can leave. He was being persistent. His girlfriend said, leave her alone. Her husband's not here, which I don't have a husband. He's my boyfriend, but that doesn't matter. Leave her alone. She said no. She comes into the dog park, and I never introduce my dogs to anyone without them being leashed. So when she came in, they didn't do anything to her. They didn't attack her or anything like that. When she came in, there's a door, a gate opening to get in, and then another opening to get into the dog park. When she came in, the door came in with her, and my Maverick got out, and I couldn't push the door out. And I was screaming, like, oh my God, my Maverick is, oh my God, you know. What Maverick has is that you can actually pick her up. Her harness, you can pick her up. He picked her up, and he went in with Chester and my dog at the opening. He put her down, and they both started going at it. I don't know which dog bit first. Once I got her next to me, Maverick, and I said, please just leave me alone, because he was still pushing the situation. And I saw that Maverick was bleeding from the face. And I said, oh my God, your dog bit my dog. I said, please leave me alone. And that's when I called for help. And I called, Stoughton Police is on my speed dial. So when I called for help, that's when he started saying, oh, you're calling the police, blah, blah, blah. You know, your dog bit my dog first. But then he said, if your dog bites, I wanted to leave, but he wasn't allowing me to leave, because all I wanted to do was leash my dogs and go home. So, and then Danny came, and then he tried to talk to Danny first, and I said, Danny, I'm the one that called you. I know Danny, that's why I call him Danny. He used to be my son's karate teacher. Okay. I did tell Danny that that's the girlfriend on the side, where he did say that she was on the side near an apartment talking to one of the ladies that lived there. She approached us while me and Danny were talking. And the Maverick and Dakota were fine, very calm, like Danny said, sitting down, everything was fine. She approached, and then Danny said, I'll be right with you. You know, because when you have an accident, you don't talk to the people all at once. You put them in, you know, you divide them so you see what the story is. When she left, Maverick started to bark. And she ran towards her, and I keep them on one leash. It's like a triangle without the three parts, because when I do them separately together, they go around my legs, and I can't move my legs. So that's why they're in that leash. So wherever Maverick goes, Dakota goes with her. Dakota doesn't have a choice. So when she left, and I saw that Maverick was starting to bark. I did everything I could to stop them from running at her. I broke my finger because I tried holding the leash so hard, and I was saying, oh my God, oh my God, oh my God. And then that's what happened. I did cover her at one time. And you'll see, I guess there's a video of a woman saying, oh my God, oh my God. That's me saying, oh my God, and it's me and Danny right there. I covered her because I didn't want anything else to happen to her. Then, yes, Danny did tase them. And I finally got control of them, and then Danny said, take them inside. And that's what I did until Danny with 2 other police officers came to the door. I took Dakota because she's the calmer, and my hands were hurting me because I had a broken finger and I had some bites too on my, it's in the report that you received. So I took Dakota, like Danny said. I followed Danny. I took her to the animal control facility. So, and then I just saw them on Thursday for the first time since the 14th. I miss my girls, and I'm very sorry that this happened.
Excuse me, Mrs. Keller, before I forget, I just want to ask you this one question, not to interrupt you, because this is very important.
Yep.
Did at any time you say to either Maverick or Dakota, stop?
Yes.
Sit. Okay, because you didn't say that.
I'm sorry. Yes, stop. I did say stop. I did say stop. So many times I said stop. I said no. I said stop. I said no. I did. Yes, I did, ma'am.
Thank you very much, Mrs. Keller. I have no further questions. Vice Chair Cavey.
I said a few additional questions. Sorry, I apologize. These are things I thought about over the last week, but I forgot to ask. First is, do you have any children?
I have one. He's 23.
23. And are there young children who are ever around the dogs?
No, sir.
Okay. I know both these dogs are relatively young, year and a half or so, maybe a little bit older. Have you had previous experience with dogs?
Yes, I had a Labrador Retriever. I bought her in '07. She passed away in 2019.
Okay. And so that was your first dog, and then now you have
Yes, that's correct, sir.
I noticed in a lot of the documentation that we've received from you that there includes documentation of some of your own injuries.
Yes.
Including, I think, a broken finger or fractured finger.
I have a broken finger. It's like right here on my right middle finger. So this right here is broken. I had to see a doctor, and I have to see him again on Friday because I went to the Good Samaritan hospital. So yeah. So hopefully it'll be fine. And as long as I can use it, I'm good.
I think it might be in the documentation, but I don't recall off the top of my head exactly. How did you sustain those injuries?
Oh, this one right here is because I was holding the leash so tightly that I couldn't hold it anymore, that the leash fell. That's what happened with this one. This one, when both dogs were on her, the closer dog that I was close to was Dakota. So I tried to get her away from the woman. Is her name Christine? Okay. If you're in an argument and somebody touches you, isn't your reaction to hit the person if you're in a fight with somebody else? So she quickly turned her head and then moved. So this is Dakota that did this to me, but it's not. I just had a fractured hand, and I couldn't go to work until Monday. So.
And the last question I have, and I regret having to ask it, but I think it's important for me to understand, because you have laid out some conditions, under which perhaps you could care for the dogs. But one of the fundamental themes of the paperwork we've seen, of the videos we've seen, is that you seem to have a difficult time controlling the dogs. And if that is the case, do you believe you could in the future control these dogs? And if the answer is yes, why do you think you can now do it when it seemed like you had trouble before?
Yes, I can control them. I'm going to have to do it separately. Like, say if if Dakota had a cone, okay, which she's had a cone, I could not walk Maverick and Dakota together. So I would take Dakota out, and then when she was done, I would bring her in and take Maverick out. That's how I would do it, and I would get that's the shortest, that leash, the triangle one, that was as short as it can go. I will get a shorter one so that they're actually right next to me. I will not let them have any leeway whatsoever. They would have to be like really by my side.
And the last couple of questions I have are you're obviously welcome to answer them, but there's based on things that your attorney sent to us. So I just want to make sure I'm understanding the purpose of some of the evidence you provided. I know you sent two examples of excerpts out of Encyclopedia Britannica. You'd mentioned that before. One is a reference to English Bulldogs, and the other one is on Bull Terriers. What were you hoping to communicate to the board based on those entries? Yeah, you're the one who sent the information. But if it's something that somebody else knows, that'd be great.
So primarily, if you look at the sign that was posted at the dog park, as well as the lease, which I know you can't take into consideration, but at least this board should consider the rules and regulations that are posted at the dog park. It's a private dog park. It's not open to the public. It's only open to residents. And restricted dogs are not permitted in the dog park. We do know that a Bull Terrier is one of those restricted breeds pursuant to the apartment complex management. We do have someone from the management here today. I have not spoken to them, but I have seen their policies. And the Bull Terrier, even though you cannot consider the breed of the dog, which is subject to this action, I think it is relevant and pertinent to consider the breed of the dog who was the aggressor in this one particular case. And you know, you're dealing with a situation where the apartment complex knows that this is a top 10 aggressive dog. It is, in fact, the first pit bull that has been bred, so it does have pit bull blood. It's a larger dog. It is naturally aggressive towards other dogs, and most importantly, and most comfortable with its own owners and not with other people. Again, you can't take into consideration the breed of the owner of this dog subject to this action, but I think you can understand that being attacked by a more vicious dog, a knowingly vicious dog, a knowingly dangerous dog, a declared dangerous dog within the apartment complex has some bearing upon the situation, and it should have bearing. She felt threatened at the time. You've heard the 911. You've seen the video initially. It's a unique set of circumstances that initiated the situation. I understand this board's sentiment. You know, an owner always being in control of their own animal is a very important thing. There's a question here as far as the attenuation of time that occurred between the initial incident where the dogs got into an argument and the dogs bit, either one bit Maverick or they both allegedly bit each other. I don't see any evidence that Chester was bit. The proximity in time that it occurred during that period of aggression, you know, was the animal's action, being Maverick and or Dakota, was it so disproportional to the initial aggressive incident that I think that spells out in the statute? I would suggest it was. I would suggest it was. And for those reasons that I think we highlighted earlier with the dog officer being, you've got dog or dogs in a hypersensitive state after being attacked, and an owner or co-owner of the dog then reapproaching them, where initially it wasn't an aggressive situation. There was no physical contact, even though they were in proximity, meaning Christine, Ms. Geller, and the dogs themselves enclosed in a pen, unleashed, not a problem. After that incident occurred, thankfully, Chester had been removed by its owner outside of the park. I would suggest to this, and again, you could revisit this issue with your dog officer. I would suggest for those two dogs, Dakota and Maverick, That incident had not yet expired. Chester had the opportunity to leave and go back to his apartment, and they did not. And then the incident ensued. Now, again, respectfully understand the sentiment that a dog owner should always be in control of their two dogs, but I would suggest the time period between that aggressive incident makes it sort of less disproportional in regards to the final incident which occurred or resulted in Christine's unfortunate biting. I hope that answers your question.
It does. You also sent a letter from the attorneys of Technology Drive regarding lease violation and dog removal. And this comes from...
I did. I can elaborate on that. It was June 16th.
Yeah, I want to understand what the purpose of receiving this as evidence is.
So just so this board knows that obviously she's ordered by management to remove her dogs from the premises, and she's complying with removing her dogs from the premises. And for lack of a better term, the threat, or at least the statement, I think that's a better statement. The statement is, until you have removed your dogs from the premises, they are to be muzzled at all times. And I think it's pretty clear in that letter, in those two paragraphs that are highlighted. Written notice that you must remove the dogs, both the dogs from the premises permanently and immediately. She's already taken action to do that, and that will occur. I do believe it's August 1st, roughly, is that date. Until then, she has been directed by management upon the receipt of this letter to keep her dogs on a leash and muzzled at all times while the dogs are outside of the apartment and until the dogs are permanently moved from the premises. So I don't believe any action has been taken in any sort of summary process matter to remove Ms. Geller from the premises. I think she's already communicated to them she's leaving, and she's doing so willingly, and they're willing to accommodate, as far as I know, that space, that permissibility for her to be on the premises, provided her dogs are muzzled at all times while on the premises, outside of her apartment.
There's a letter that you provided to us from Yessie and Yessie PC regarding our client, Christine Wilson. This appears to be civil litigation, if I'm understanding it correctly. In providing that to the select board for this hearing, what was the purpose of, what do we mean to understand by that?
What should be understood by that letter is that obviously this is a civil matter. It's being pursued by Christine, understandably, and Ms. Geller does have insurance, more than sufficient enough insurance, I believe, to cover any sort of incident like this. And her insurance company is continually willing to insure her, even going forward, and that's important. Obviously, I don't believe that management in this one particular case has any liability, although you never know. This is the world of torts. And as I learned in school many years ago, it's everyone on the kitchen sink. But that doesn't have bearing upon this matter. And I don't believe the town has any liability in this matter, nor does management. The proper disclosures were given. And Ms. Geller is properly insured for those dogs and always has been. So this is not a situation where I suppose the bite will go uncompensated, and it should. I'm
sorry, would you mind moving the mic a little closer? I'm trying to read your lips, but I'm struggling with that as well.
So this is a situation where, so to speak, the bite will not go uncompensated. The victim will be made whole.
Okay.
To the best they can, obviously, without.
Sure. I just want to understand that we received this. None of it's been addressed in any testimony, so I want to figure out what I'm meant to understand by it.
Certainly.
There's also a letter from her vets. This is pretty clear cut. Her veterinarian is essentially saying that she has not witnessed any aggression.
So the packet I provided that includes evidence of both dogs' vaccinations, as well as a report of the veterinarian's observations of those dogs when they come in for their vaccinations, routine visits, upkeep, and any sort of medical visits, that they were always well behaved. They never instigated any sort of fight or anything like that. And obviously those opportunities are there for engagement. If anyone's ever been into a veterinary hospital or a clinic, they know that dogs are freely pretty much about, even though they may or may not be on a leash. So that's important. If they ever had a bad experience with a dog, I'm sure that that facility would not want them back, and or give them advice on what needs to be done for those dogs. So it also buttresses the statement that she takes good care of her dogs. She has her dogs licensed and always properly licensed with the town. She's doing everything a good owner would and should do, and that's important. I don't know about the other dog. I can't say that, but I can say that she's complied with all the town ordinances regarding the dogs being properly licensed at all times, tagged, vaccinated, and leashed, or at least with a collar when in a confines that doesn't require a leash. So for those reasons, she's been a good owner and had prior success, obviously, very long term with a I'm sorry, was it a Labrador?
Yes.
Yeah, with a Labrador for a considerable period of time.
Yeah, I have one last question then. And the very last question I'll have is there's an email in here which seems to be from the Bell Partners, Inc. regarding a noise complaint from April 28th. And it appears to be that somebody else had complained of noise coming from Ms. Geller's house regarding dogs barking. And I would like to just understand how this fits into this particular case.
I don't believe that was my submission. I think that may have been someone else's submission. If it was somehow included in that, it may have been attached to some sort of letter from management. I'm not aware of that.
Okay. See, it's like
maybe Ms. Geller can help.
Maybe it's just the package I'm looking at, but it looks like it's in between two different letters from the VNA or from the VCA.
Okay.
I sent that. I sent all the information that I had. My dogs were barking when it was quiet time because they heard noises either in the hallway or outside. That's why that was a noise complaint.
I appreciate your time. Thank you very much.
Thank you.
Mr. Gito.
How long do you, and how many times a day do you take your dogs out?
Sir, I take them out when in the morning. I take them out when I come home from work. And then usually John, my boyfriend, takes them out again. I do it Monday through Friday. When John gets home, he does it once. And then John does it throughout, he does it on the weekends because I do it through Monday through Friday.
About how long each time?
Oh, it could be a half hour in the dog park. Each time it could be 45 minutes in the dog park. Because
what about normally? I mean, I can understand.
Oh, if it's raining, it's like do your business and let's go. I mean, if it's snowing, do your business and let's go. I don't, if it's thundering, yeah, no, do your business and let's go.
Thank you.
You're welcome.
Well, let me use the microphone. I think, Madam Chair, we're almost concluded with Ms. Geller, and then you could turn it over to the witnesses who are attending online. But I don't mean to interrupt anyone. If anyone had any more, yes, exactly.
Pardon me for my forgetfulness.
It's okay.
You said you're going to move to Avon, I believe.
No, sir, that was an example. I am not moving to Avon. I am moving somewhere else. Do you want to know where or?
No, I don't need to know what town it is.
Okay.
I thought that's where you said. But my question is, what are the conditions of the place you're going to move to? Is it another apartment? Is it a single-family house, a two-family house,
It's a loft building, a warehouse that became lofts. There is no dog park, so I will be walking them separately to do their business.
And where will you be watching them?
Where will I be watching them?
Are they going, is there a lot, you said?
No, there's a lot. It's a loft. Where,
apartment.
A loft apartment?
yes.
A large one-bedroom. A large one-bedroom, which is actually bigger than her current two-bedroom unit. It's open space.
Yes.
That way.
The reason that I asked the question is when I started my questioning, I asked if you would be willing to do the things that were in Chapter 140, Section 155, I believe, or 157, one of which was to have a enclosed area for the dog with a roof, and if it didn't have, so the dog couldn't get out and would also be protected from the elements. It doesn't sound like the loft that you're going to be living in would accommodate that kind of situation.
They stay in crates when I'm working and where John's working. They have their own extra large crates, both of them. And I also have gates inside the house, where I live now, it's a foyer, so there's a gate there, so with a door that you can open and shut. And also I have one in the kitchen going to the dining room, same thing. I have actually 3 gates, but I'm using 2 of them.
Thank you.
You're welcome.
Madam Chair, if I make a suggestion, if there aren't any further questions for Ms. Geller, we might turn to the witnesses that are available online. In any order, would you want to proceed?
Yes, before we proceed with line, I just wanted to ask the young lady in the audience to please state her name, and I wanted her, if she's here for not a witness, but she has personal knowledge of the case or can add value, I wanted her to be added to the list.
Okay, so if there's
Because we
any
didn't
members
recognize
present in
it.
the room who wish to testify,
Yes.
and so are there any people, if I may ask through you, Madam Chair, to the audience here tonight, is there anyone here present in the Great Hall that wishes to give testimony this evening that hasn't already? Anyone who wants to address the board on this matter tonight? Madam Chair, would you like? Madam Chair, we have a person rising. Would you like to recognize her?
Yes, please. Please step forward to the table and so we can see you and we can hear you a little bit better because of the cameras and the angles of the cameras and things like that.
I'm Samantha Fontaine. I'm actually the assistant community manager at Stoughton, so I work in the office at the location where this happened. I don't have a statement, but I didn't know if you had a question or you referred to me in the audience. I'm just here for informational purposes as far as the communities involved.
Did you say you worked in the office of the
Correct.
apartment?
I'm the assistant community manager of the Stoughton community.
So, thank you very much. Mm-hmm.
Sure.
No questions. Please proceed, Attorney.
I have a question. Pardon me, ma'am.
Yes.
Sorry.
How many units in your complex?
The community has 240 apartments broken up into 4 different locations, 4 different buildings.
248.
240.
240.
Yes, sir.
How many have dogs? About?
More than half.
Thank you.
Thank you very much.
In that case, Madam Chair, would you like to move on, if it's your pleasure, to those attending online? I believe we have Ms. Wilson and Ms. Cardula.
Yes, please.
Any order you'd like to take them in?
Ms. Cardusa, Christine.
Just Paula Cardulo and
Paula.
Christine Wilson are the 2.
Christine Wilson, please. first? Okay.
Yep, if that's your pleasure, Madam Chair, then
Yes.
Ms. Wilson.
Hi.
And Ms. Wilson, I don't believe you were in attendance on July 5th when we opened this public hearing.
I was on the Zoom meeting the whole time.
Okay, and did we swear you in? Are you?
No.
Okay.
I didn't speak, so.
Okay, well, just out of an abundance of caution, Madam Chair, would you like me to swear her in just through you?
Yes, please.
Ms. Wilson, do you swear that the testimony you're about to give to the board and the proceedings in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
And Madam Chair, she's not appearing at anyone's request. I believe she's here on her own accord. So rather than examine her, question and answer style, I'm more than happy to just allow her to make a statement if that's your pleasure.
Yes, that is my pleasure. Mm-hmm.
Do I have a pleasure that I speak, with questions only?
Ms. Wilson, the chair has invited you to make any statement you see fit to.
Okay.
So I'm not going to ask you any questions. The board may have some follow-up questions for you after they hear from you.
Okay.
But this would be your opportunity to make any statement you wish to give to the board for them to consider.
I guess the statement was clearly there's a horrific event that you all know about, and I've been going through a lot since then, which I'm on my 5th infection, and I've had to be in the ICU in and out for a week still. So, as far as I'm pretty traumatized, I can't even be around another dog. So, that's pretty traumatizing. And I can show you my leg. It was down to the bone, there was flesh on the dog's mouth. A flesh missing from my leg at 9 different spots. So, I just wanted to be able to speak. I don't know. I don't really know what to say, but I'm going to need orthopedic and prosthetic, orthopedic and orthopedic surgery and then plastic surgery after that to even just be okay to walk on it. If I was a little girl or one of the 200 little girls that lived there or boys, they would have been dead. Or if she hadn't called the police on my dog for out of no reason. And I just want to let you know that my dog is a bull terrier, but he is an emotional support dog. He's trained for a year, and he's gotten letters from the vet that show that he is not aggressive in whatsoever. So the apartment complex has all of that information. So in order for us to even allow a bull terrier here, he had to get approval. So he's not aggressive. He's friends with many other dogs here, and this has never been an issue. I don't know. I just don't really, I feel bad for the dogs because I understand it's the owner and not the dogs. And it's hurting me to even have to come to these videos. It's crushing me. I know how hard it is. I couldn't even imagine. But it was probably the most horrific thing that's ever happened to me. It definitely is. And even the detective and the animal control said it's the worst fight they've ever seen. So I just don't feel like how it would be safe to have dogs that aren't able to be controlled walking around, whereas that woman had them on a tandem leash. She said that it went at Chesty on a leash. It went off on him on a leash? No. And the reason I was only ever in the park was just to check, because it's the law that if someone says your dog hurts another dog, you have to go check on that dog. That's why I went in the dog park. My dog was not in the dog park. And both police officers saw that there was no bites or whatever, same with animal control. I mean, I checked it out myself. And that's the only reason I was ever in there. I was never in there when I got attacked. There was no provoking. I was talking to Paula, my neighbor, and the only thing I yelled was to the officer. I said, I'm the second party. So if you could talk to me afterwards, that's it. So I don't really know how it provoked it or how the breed of my dog should even have anything to do with it, because the breed of her dogs are just the same. Clearly worse. And I mean, I can show you guys my leg, but it'll probably, it's probably too vicious to show on camera, so.
Madam Chair, may I ask a
Yes, please.
clarification question? I don't know if anyone else can hear it, but I hear another voice coming through, and I want to ask Ms. Wilson if she's alone. I believe there's another individual that may be with you, or maybe you could clarify that. Are you by yourself on this Zoom, or is there another individual with you?
Oh, I'm Aaron, her boyfriend. She's just having a hard time.
Yeah, I'm just having a hard time speaking. And
No,
saying
and
what
I'm raising it just so that the record is clear who's giving testimony, because I did hear two voices. And since only Ms. Wilson had identified herself, I just wanted the record to reflect who we're hearing from for the benefit of the board. And so, sir, your name was Aaron?
Yes, Aaron Muse. I was the one who was holding Chesty. She's just having a really hard time. She's upset, so I'm trying to help her say what she's got to say.
Thank you for clarifying, sir.
No problem.
Did you want to give any statement? If so, we would swear you in, but if we're just receiving Ms. Wilson's statement, then that's fine.
Okay, I apologize for that. She's having a really hard time trying to speak right now because she feels bad for the dogs, but she doesn't believe that they should be around anymore. Here's Christine Wilson. I'll be quiet.
And to the board, you've heard Ms. Wilson's statement. I didn't want to interrupt. If you were finished, ma'am, if you're not finished, you can continue, of course. But if you are finished, I'd like to ask if the members have any questions for Ms. Wilson.
No, I think I'm finished.
Okay. So through you, Madam Chair, to the board, if the members have any questions for Ms. Wilson.
I have no questions.
Have no questions.
With your permission, Madam Chair, I'd like to invite Attorney Moriarty if you had any questions. Well, we haven't finished with Ms. Wilson. And so we had a chance to ask questions, and now I'd like to give Attorney Moriarty a chance to ask questions, and then we'll finish with Ms. Wilson, and then we'll move on to the next witness. So, Madam Chair, if it's okay with you, Attorney Moriarty, do you have any questions?
I have no questions. Thank you.
Okay. Thank you, counsel. And then back to you, Madam Chair. If it's okay with you, I'd like to thank Ms. Wilson for attending this evening and giving testimony. And then I believe we have Paula Cardula.
Yes.
And so if we could proceed with Ms. Cardula. Ma'am, I believe you were in attendance on the 5th, and I believe we swore you in. Is that correct?
I was not sworn in.
You were not sworn in?
No, I did not have a chance to speak that night.
Okay. Well, ma'am, are you going to activate your video this evening? We don't have video. We only have sound.
Yes, I'm good. Is that good? Yeah, I'm good.
Okay. Thank you very much.
Yes.
So through you, Madam Chair, to Ms. Cardula, if I could swear her in.
Yes, please.
Do you promise that the testimony you're going to give the board this evening and the matter before it will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. And if we could follow the same procedure as we did with Ms. Wilson, So, Ms. Gardula, I'm not going to ask any questions or lead you. You're not a town witness. We didn't ask you to attend or subpoena you. So this would be your opportunity to give any statement you wish the board to consider in this matter. And so this is your chance to state whatever you would like.
My name is Paula Cardulo, and I reside at 408 Technology Center Drive. My unit is directly across from the dog park. I am also a dog owner and use that park frequently. Although I can't use that dog park when Miss Geller's dogs are in there because it's too difficult because they are too aggressive. I can't walk past Miss Geller with my dog because her dogs are too aggressive, and she warns me, she fair warns me not to walk by her until she is passed because she can't control her dogs. On June 14th, I was alerted to commotion outside of my balcony at the dog park, and I opened the door to step on my balcony where I witnessed Aaron and Miss Geller in a confrontation at the dog park. Miss Geller's dogs were aggressively attacking the side of the chain link fence, literally crushing themselves into the chain link fence. Miss Geller was pleading with Aaron not to bring his dog inside. However, Aaron was adamantly pointing to the dog park rules and yelling that no aggressive dogs are allowed in the dog park and her dogs should leave. Miss Geller made no attempt to remove her dogs from the park at that time. I don't know what ensued after that, but I did hear that Miss Geller called the police. When the police arrived, I heard the detective ask Aaron to bring his dog back inside the apartment. Now, Miss Geller earlier stated that on the video she was yelling, "Oh my God, oh my God." That was not her, that was me, because I was taking the video. I saw the whole thing and I was videotaping it. So when the police arrived and Aaron brought his dog back into the apartment, about 6:23, Christine walked over to the detective to tell her side of the story. It was at that time I witnessed the gruesome attack on Christine's legs. Both dogs were lunging at her and she toppled to the ground. One dog had a strong bite hold on Christine's leg, like a dog to a stake. Miss Geller had the leash in hand and was yelling and punching her dogs, trying to pull them away. But it became a physical challenge and Miss Geller lost control of the leash. The dogs then lunged at Christine again, and the detective tased the dogs, making them run to the entrance of the park. The detective yelled at Miss Geller to go get her dogs. Miss Geller was visibly upset and tried to get her dogs while screaming. She finally got a hold of them, and Christine ran back over to my balcony in shock, and we waited for the ambulance. In wrapping up my statement, I just want to reiterate that this was just an awesome, gruesome attack to witness, and I have seriously had nightmares myself about it. While listening to the hearing on 7/5, I was disturbed, to say the least, to hear a needless and irrelevant comment of comparison by Mrs. Geller's attorney that he had also been bit by a dog once in the face. With all due respect, if anyone had been bit in the face the way the dogs had mauled Christine's leg, your face would be disfigured. I witnessed Christine being mauled by the dogs. Her wounds were to the bone. In my opinion, this was a high-level dog attack, not a little bite. And you can say all you want that Ms. Geller can be a good dog owner and take care of those dogs with license and vaccines and whatnot, but that is a very small part of taking care of dogs. I am a mother and a grandmother of 4. My grandchildren visit my apartment. I just pray someday that nothing ever happens to them, that what happened to Christine, because they wouldn't be here. It was vicious and gruesome. That's the end. Thank you.
Does the board have any questions for Paula Cardula?
I have no questions.
I have no questions. No, the board has no questions.
No questions.
And Madam Chair, I'd like to just do a last call and see if there's anyone else that we didn't recognize that is either in the room with us tonight or online that would like to address the board? I'm not seeing any hands go up. Unless anyone disagrees with that, I think we're just about done then with testimony and evidence. One last housekeeping matter is that I've informed council of this, but the videos and photographs and other things, there are a few things that obviously we can't put in a selectman's packet. And so the board knows this. I'm just going to state it for the record. We created a folder that was made available to the board members. They've all seen it. They've had it available to themselves. And so to the extent you want to reference it or rely upon it, well, we all have that. And so even though we didn't display the videos, they're available to the members. So before we close out the public hearing, at your discretion, I would normally give council a chance if you wanted to make a closing statement or anything to kind of summarize their position. And he doesn't have to, but I'd like to give him the opportunity if that's okay with you, Madam Chair.
Yes,
Attorney Moriarty, would you like to approach if there's any kind of closing statement or anything you'd like to state to the board at this time?
Sure, thank you, and I'll be brief. I'll start just briefly with some of the public comment that we occurred. I would ask this board to some point, discredit slightly the victims, some of the victims' statements. It was very bizarre testimony. I did hear in the background that it sounded like it was being coached. And the other gentleman, Aaron, who was the party to this, had said things on behalf of her that she did not say, and that was that she wanted the dog put down, but that wasn't her statement. So I don't think I ever heard that statement, except for it was by someone else said on their behalf. And it was just bizarre. I'd never heard something like that before. So to that extent, I would ask this board, consider these two dogs two separate cases, and they are in fact two separate cases. The case of Maverick and the case of Dakota, I would suggest pursuant to your statute, and I will let your town council advise you as far as what the statute exactly says. And it's pretty clear what the statute says, and it's just a simple matter of applying the facts to what your findings are. Insofar as you can either A, dismiss the complaint, you can find the dog a nuisance, or you can find the dog dangerous, in which case you do, in the case of dangerousness, have the ability and the power to order the dog or dogs put down. If this board finds that the dog is a nuisance, there are specific set of circumstances, as well as other circumstances that this board can customize to accommodate for a nuisance dog without having to issue that order to put them down. I think Dakota falls in the first category at the very least of this case being dismissed against it. There is no allegations that it bit anyone except for in the heat of its tussle, grazing its hand against its owner. I'm sitting up very close. There was no direct puncture wound. It was more of a fracture that occurred due to the leash, as well as the turning and probably the grazing of its canine. So you've heard her testimony. You know what she said. As far as any other person having Dakota biting them, I feel terrible, because it's almost a case of almost guilt by association. You know, it was taken along with Maverick and sort of scooped up and put in a pen, put in quarantine for 10 days, in the same surroundings that it was removed from its owner, removed from its comfort, and put in just not the same conditions it would have been in the apartment, to say the very least. When Miss Geller saw her dogs, they were slightly unkept. They were, they were dirty. And understandably so. It's not going to get the same care an owner is going to give them. But for those reasons, I don't think we've seen that Dakota is displaying anything other than being sad and not aggressive behavior. It's not gnawing on any chain. It's not gnawing on any fence. And it didn't bite anyone, most importantly. So for those reasons, I think this was a good case for it being dismissed. Should this council find that this dog is a nuisance, I think there are more than enough accommodations that can be made to let this dog live. This dog is 1 year old. We don't take a 7-year-old child and put them down or order a kill order on them because they bit someone in school. And I think the same situation sort of lies here in the fact that this is a life. And I think it shouldn't just be taken off this planet just so liberally, especially considering the circumstances regarding Dakota. Circumstances regarding Maverick are admittedly different set of circumstances. And should this board find that this dog is a nuisance, obviously I don't think the capability for Ms. Geller exists in building an enclosure on land she does not own in order for the dog to never ever be sort of matriculated back into dog and human society. Nor do I think that that would be necessary. I think all the other accommodations would be, and would be not only embraced by Ms. Geller, but would also be more than appropriate, that being if it is ever outside that is tethered, and it is always muzzled if it is outside. I think that's appropriate. I know this board, pursuant to the statute, and your town council will advise you on that, it also has the ability to have a microchip put in it, together with the order that it also be registered and notice of your findings be filed with the town she lives in. I think that's more than appropriate. This is a Mass General law, so a violation of that would be a crime, a criminal act upon its owner. And should anything happen or arise in the future, I think that any licensing authority for a town would be more than happy to fulfill this board's request that the dog sort of report before its supervising town council, wherever that town council be. And I think that the town would embrace that opportunity to do so, knowing that a dog that has been a nuisance is regularly before this board and sort of had a checkup. Any sort of behavioral training, I think, would be appropriate. Any sort of one-on-one training, as well as exposure to a licensed trainer that can sort of integrate the dogs more into dog society. I think that's more than appropriate. To say that this dog, who has an estimated lifespan of 14 years, it should just be ended after one, in Ms. Geller's words, it is in fact a puppy. It's a child. So for those reasons, and I understand your town council will advise you on the law. You've heard all the facts. I want to thank you for your time. On behalf of Mr. Geller, I want to thank you for your time as well. And you have the evidence, and that's all. Thank you.
So, Madam Chair, before we close the public hearing, does anyone have any questions, or are there any housekeeping matters we should attend to, or do you feel that it's appropriate at this time?
Vice Chair Cavey.
Yeah, so I think our animal control officer was here for a while, but she may not be here any longer. I did have some questions for her just regarding observations over the past week. Is there anybody from the police department who could speak on her behalf, or is she here?
Oh, excuse me, Vice Chair Cavey. I did receive an update from Deputy Chief Holmes. She had another engagement. That's the reason she left the room, but she is able to come back. But I'll defer to Deputy Chief Brian Holmes.
Thank you. She had a call out, so I can call her to get her back here. It just might take a few.
Well, I don't want to stall things, but on the other hand, I would like to get her observations. I think they might be valuable to know. Now she's spent an additional week with the dog, so if it might be worth just having a recess until she returns, if other members of the board are amenable to that. I appreciate that. Yeah. So
how much time would you need? Maybe 10 minutes, or?
She had to pick dogs up and bring them to the shelter. So I'll just call her and find out.
Okay.
You're looking for any noteworthy observations over the last week? That's
yes.
What you wanted to know?
Yeah, I just wanted to know any updates on observations over the last week for both dogs.
Oh.
Okay.
She could zoom in.
Mm-hmm.
Okay.
Take a break, Deborah, then?
Yes, in the meantime, we will take a 5-minute break and then we'll just go from there because we need. Okay, with that, a 5-minute break for starters, and let's go from there because she may be able to just zoom in right now. Okay, once again, testing. Dolores, can you hear us?
Unrelated to this. Yeah.
Yes, Madam Chair.
Thank you so much. Okay, we reconvene the Select Board back to order this evening, July 11th at 9:55 p.m. And Brian, did you?
So when we, if I may, just sort of pick it up where we left off.
Yes, please.
When we recessed briefly, Selectman Cavey had asked a question. The witness that we believed who would be appropriate to answer it wasn't available. We have since made contact. That was Animal Control Officer Carlos. She's spoken with Deputy Chief Holmes, and Deputy Chief Holmes is prepared to give that answer. So if that's acceptable to Selectman Cavey and to the board, we can proceed and we can have that question answered now.
Yeah, that'd be perfect. Procedurally, does the Deputy Chief have to be sworn in for this testimony?
Yes, I would like that.
Perfect. Okay, thank you.
Deputy Chief Holmes, do you solemnly swear that the testimony you're going to give to the board in these proceedings will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Would you like the question repeated, or are you prepared to answer, sir?
I'm okay. So the question posed to the Animal Control Officer was, in the last week, have there been any noteworthy changes with the dogs? And the answer was nothing noteworthy, just that they're acting better and they're warming up to the Animal Control Officer.
Thank you.
So I don't mean to get ahead of the board, but if that concludes the evidence and testimony, then this would be the time, if the board's comfortable doing so, to close the public hearing, and we'll move into deliberations.
Motion to close the hearing.
Can I get a second on that?
Second.
All in favor?
Aye. Aye.
And I vote aye as well.
Okay, so the public hearing is now closed. That means the record is closed. You have all the testimony and evidence that you're going to rely upon for your deliberations. Just so you know, I'm not going to give a summary, and although I do feel it would be helpful to kind of recap the testimony, 2 reasons. One, I'm mindful of the board's time and the hour, but 2 is I'm trying to serve principally as a hearing officer and a neutral here. And I have a concern that my rendition of the testimony may inadvertently suggest my thoughts, feelings, and opinions on the case, and that's the board's job. And so I don't want to do that. I'm happy to help you through any questions you may have on the evidence. You've got the documents in front of you, the videos, you heard the testimony, so I'm happy to answer questions about that. If there are any concerns or questions about the testimony or evidence that came in. But I'm not going to sort of give a closing statement because I don't want to inadvertently become a prosecutor here.
Understand.
So that being said, the next task before the board is how are you going to reach your decision? And so what I'm going to suggest is that there are 2 dogs here, and so we're going to need to go down the sort of checklist that I've provided to you that tracks the statute and make determinations as to each of the 2 dogs. Now, the final written decision, which I'll ask you to instruct me to write when we're done here this evening, it can be one decision for both dogs, but I will make it clear in that decision whatever decision is reached for each of the dogs. So we'll have a section for one, a section for the other. The owner may wish to appeal one but not the other, and so it's important that we're clear which findings apply to which dog. So where I'd like to start, and I'll just be as brief as I can because you have the language right in front of you, so I'm not going to read it to you. This. So it's the one document that you have with my letterhead on it.
That's this one?
It is, yes. And I hope everyone has that. But I'll just sort of summarize it very briefly. So the first finding you have to make for each dog is whether or not it's dangerous, a nuisance, or neither. And so those are defined. And then right at the top of the first page, those definitions appear. If you want to find or are considering finding that the dog is dangerous, there are exceptions to that, and that's at the bottom of the next page. The heading, of course, is exceptions. And so the statute states that you cannot deem a dog dangerous solely based on growling or barking, or 2, based on the breed of the dog, or 3, if the dog was reacting to another animal or to a person and the dog's reaction was not grossly disproportionate to any of the following circumstances. The dog was protecting or defending itself, its offspring, another domestic animal, or a person from attack or assault. So if it was protecting itself or defending itself. The second one is the person who was attacked was committing a crime. The third one is if the person attacked was engaged in teasing or tormenting or otherwise, provoking the dog. And the fourth one is if the person attacked had breached an enclosure in which the dog was kept separate and apart from the public. So obviously I'm paraphrasing those, but those are exceptions. And so if you feel that any of those apply or could be invoked, you should consider them. And I can explain more if those become something you want to discuss in more detail. But if you find that those don't apply, then we should talk about whether or not Maverick is a nuisance, Maverick is dangerous, or neither, and then the same for Dakota. And now once you make that finding, then we can talk about the actual order, because you can't issue the remedies until you've made a finding that the dog is either a nuisance or dangerous. So that has to precede any kind of remedial order you might issue. So I think first things first, and we can go in any order you want to go in, Dakota or Maverick, but I think the board should discuss what was the evidence for each dog, and you may want to entertain a motion for the sake of discussion or however you want to proceed, but we'll need one of those findings for each of the dogs.
Thank you very much, Attorney Winter. I would like to go the route of motion, and that allows us to discuss. I would like to start with Maverick and then discuss Dakota. Is everyone in agreement with that process?
Sure. Madam Chair?
Yes, Vice Chair Cave.
I make a motion that based on the evidence that we've heard, Maverick should be deemed a dangerous dog pursuant to General Law, Chapter 140, Section 157.
Is there a second?
Second.
Okay. Is there any discussion?
I'll just briefly give my justifications for this, and it's strictly out of the chapter itself. Dangerous dog, a dog that either without justification, attacks a person, or domestic animal causing physical injury or death. In this case, Maverick did attack a person, and it caused physical injury. With regard to the exceptions, Maverick's, based on the testimony, both the report and the testimony of our detective, Detective Barber, I believe that none of these exceptions apply in this case. It was not solely based upon growling or barking, or solely growling and barking. It wasn't based upon the breed of the dog. If the dog was reacting to another animal or to a person, the dog's reaction was not grossly disproportionate to any of the following. Grossly disproportionate to any of the following circumstances. The dog was protecting itself or defending itself. I don't believe that is the case. It seems like this was unprovoked. The person who was attacking or threatening the dog was committing a crime that did not occur here. The person attacking or threatened by the dog was engaging in teasing, tormenting, battering, assaulting, injury, or otherwise provoking the dog. And that it comes about as close as you could possibly get to this case, and there was no evidence that happened. Ms. Wilson was simply walking towards the officer when this attack occurred, and I don't think it's justifiable to say that qualifies as teasing, tormenting, battering, assaulting, or injuring, or otherwise provoking the dog. In the last case, similarly, they weren't in an enclosed space that was being breached. So for those reasons, I find that this fits within the definition of the statute. This case for Maverick fits within the definition of the statute.
Any additional discussion? Mr. Gito.
I think I agree with everything that was said, and we saw video of the attack itself, and the testimony of the dog just going after the person. There was nothing to indicate that the person had done anything to provoke that kind of attack. I mean, I went up to the site and looked at the dog park, so to speak, and it looked just like all the pictures that we saw. The space was not very far from the apartment to the dog park, and it was absolutely clear to see that what had happened, and then looking at the actual pictures of the victim's leg, Christine's leg, due to that attack. It was pretty gruesome from my perspective. It wasn't something that I would want to have happen to me or to anyone that I know or don't know.
If there are no further comments, then on the vote, the motion, take a vote on the motion.
Aye.
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 And I vote aye as well. Unanimous decision. Next, is there a motion on Dakota?
Without, if anybody feels differently, by all means, I'm willing to find consensus on this motion. Given the statute, my understanding of the statute and the facts that we've had access to, I currently do not find sufficient evidence to persuade me that Dakota is either a dangerous dog or a nuisance dog. There is evidence to suggest it in this particular case. Actually, let me just start by simply making the motion to find that Dakota is neither a nuisance dog nor a dangerous dog.
Second.
Discussion?
Okay. So my justification for this, this one is something I have to be honest, I do have reservations about, because it does concern me that Dakota was so aggressive while in her cage in the pound. On the one hand, there's no evidence of her having bitten anybody that I'm aware of, or there was no witnesses to that. There was the idea that she would be especially aggressive, I feel might fall within some of the exceptions here, where the dog was protecting or defending itself, though that is perhaps a perception of defending itself. And its lack of socialization might have contributed to that. I'm out on a bit of a limb here, though, and so I'm not going to speak as though I know how to make these judgments, at a sort of pet psychology level. But I struggle with that. There may not be enough evidence to suggest that she can't be rehabilitated and more or less will go on being the dog that she was before, which sounded was not aggressive, not especially aggressive. But I do, as I said, this one I'm far less certain of.
Mr. Gito.
In the attack on Ms. Wilson, it didn't seem as though she was the perpetrator of that. She may have got pulled into the area because she was on a tandem leash, but I didn't note anything that she did that was out of the ordinary for that kind of a situation. I mean, I think there's a difference between being dragged into an area where something happens and being a perpetrator or something like that. And I didn't see anything like that occurring. I mean, we see on the news every night that people are sort of get caught up in a mob. This wasn't a mob, but she couldn't get away either. So I agree that she, from my perspective, didn't begin an action and didn't take action that was excessively aggressive in that situation. And as for the being at the kennel, I have no way of judging how dogs act in a kennel, whether or not they all act the same way when they're cooped up for a week in a different location. So I have no justification one way or the other of saying that she might have been a nuisance dog in that situation.
My assessment is when Dakota was actually in the kennel and the dog control officer said she was very aggressive. So I questioned, what was the trigger to that? Okay, so the dog officer said it was because of fear and probably something else. I look at the dog officer with her years of experience and her background as being an expert. in behavior as well. Today, we heard the dog officers say, well, within this remaining period of time, within the last week or so, what has been Dakota's behavior, and the response was, she's warming up. She's warming up. So that led me to believe, because I just thought that she was dangerous. Something is a catalyst to trigger her fear, and then something allows her to warm up. But this next incident might be something, might be another catalyst, but we can't understand what that is for a trigger for her to start being aggressive. And I also thought about, we've already solved the case, or we've responded to the situation with Maverick, so maybe it was Maverick, yes, that was the aggressor at that time, so Dakota didn't need to be aggressive, but when she got to the kennel, she found that she needed to be aggressive with no real reason other than fear, and this is to a caretaker that was giving her food, and I'm sure in the type of professional, caring manner that a dog control officer would give. So why would she be aggressive to her caregiver? So I do believe that she's dangerous. But the motion on the table is that Dakota is not a nuisance dog or a dangerous dog. So did anyone else have another observation that I did not? Maybe it's something that I did not pick up, but I just questioned about what was that catalyst other than that fear, and how intense will that fear get? Thank you, Mr. Carrara.
I was gauging my comments on this dog by the same idea that you would. And when you take the college class of psychology, it says when you put a sane person in a locked room, they go insane. When you put the insane person in, they sit down and they're waiting for their meal because it's doesn't bother them. This dog was like taken out of its element, and it didn't have its buddy to lead the way, because one's dominant, one's going to be submissive. And if Dakota sees Maverick do something, it'll mimic. So that, like when the dog officer spoke about pack animals. This one didn't bite, so maybe it has a chance because it doesn't have the taste of blood. The other one that just laid down is docile. It's like a shark waiting for another chance, another bite at the apple. And maybe Steve's right. Maybe we're wrong. But that's where I am on that one.
So then the next thought process is what could answer that question. So that question mark that I'd have, because we are here to make sure that the public is safe. So is that training? Is that not like a detailed training? Is not like your friend that says that he used to train his own dog, but a professional trainer.
The only thing that makes me nervous in the line of thinking that you're thinking, I'm with you on it, is that Ms. Geller said the dogs have had no formal training.
Right. Mm-hmm.
They are now a year old. I don't know how old this one is, Dakota. I forgot, but the first year is the year that you bond with the dog, and the dog learns what it's doing. Just putting it in a crate just keeps it from not messing in your house or tearing things apart. It's not teaching it anything. Those dogs are like rubber bands all day long. They're turning. And then when they get out, and they were in the dog park, that became, because they were there first, it's their dominant, it's theirs. And that's, so it could happen again, so.
Vice Chair Cavey.
Yeah, so we find ourselves perhaps in a little bit of a paradox. I could be wrong. I would lean on town council. Our job here is to make a judgment based on the statute. And in the case where the dog is neither a nuisance dog nor a dangerous dog, sounds like, based on the statute, we have no role beyond that if we deem that neither of those is true, and we can't make any sort of requirements if we deem the dog to be neither a nuisance dog nor a dangerous dog. Is that correct?
Yeah, I was trying to find, oh,
Sorry.
yeah, but I was trying to find the language in here
So,
that the officer said.
Vice Chair
Yes,
Cavey, that is correct. If you don't find the dog to be a nuisance or dangerous, that ends the process for that dog. And so in order to issue any kind of remedial order, the dog would either have to be a nuisance or dangerous dog.
Yeah. So
Threshold finding. Yeah.
Yeah. So that was my understanding. I appreciate the validation on that. The problem is, though I do believe these dogs, both these dogs and Dakota as well, really need some formal training. I still can't deem the dog to be a nuisance dog or a dangerous dog based on just my understanding of the evidence and the statute. So even though I think that's important, the fact that if this vote passes, then all we could really do is just, as neighbors, recommend or suggest or ask nicely, please train the dog. But beyond that, I don't think we have any authority beyond that. So,
Madam Chair, may I just make an observation?
Yes, please.
And just for Vice Chair Cavey's benefit, the nuisance definition, is a three-pronged definition. And the first two, obviously, excessive barking, that's not the factor here, right? The third one, threatened or attacked livestock, animal, or person, also not particularly applicable based on what I just heard by way of comments to Dakota. The one in the middle, though, too, it starts off with excessive barking causing damage, but there's, after the or, it says, or other interference a reasonable person would find such behavior disruptive to one's quiet and peaceful enjoyment. And so that's a very broad, low bar to being a nuisance, disruptive of one's quiet and peaceful enjoyment. And so I know we all have a common sense, understanding of what a nuisance is. Clearly dangerous, we all do, and nuisance as well. But again, I think when the statute was revised, it was revised with an understanding that in order for the board to issue a remedial order, there had to be a basis. And the threshold basis to do that was to determine a dog was a nuisance. And so if you weren't going to find a dog dangerous, they didn't want to leave a board with no options. And so there's this lesser finding that if a dog is, quote unquote, or it can cause interference, a reasonable person would find such behavior disruptive. That's a much lower, sort of burden of proof. So I'm only highlighting that, I'm not suggesting anything here, but just to make sure that if the board wishes to, it has the opportunity to consider whether or not that might be an appropriate finding.
yeah, and I have number 3 in there also, perhaps fits. It has threatened or attacked livestock, a domestic animal, or a person. And I don't believe Dakota's necessarily attacked, but it sounds like the case in the kennel might qualify as threatening. But such threat or attack was not grossly disproportionate reaction under all the circumstances. So I think that might also fit if we view this behavior in a kennel as threatening the staff there and the animal control officer, but also that we don't think that it's it's having threatened was disproportionate given all the circumstances, and that includes the absence of training and socialization, just the anxiety of having been a party to the attack and now being isolated. So a nuisance dog might also fit if we wanted to ensure that there were also some just additional effort to protect the public from any sort of future attack. That I feel probably pretty comfortable about.
Yes, I would too. Mm-hmm.
So I'm going to withdraw my motion and move that Dakota, based on items 2 and 3 in the definition of nuisance dog, that we determine that the Dakota is a nuisance dog.
Second.
Okay. Is there any additional discussion? So it's a motion on the table. It has been seconded. Any additional discussion?
I understand where this is going and why it's going there. That in fact we want to make sure that the dog gets some training. I frankly would like to see the owner being willing to do that without also causing the dog to be considered a nuisance dog. It just seems like the right thing for the owner to do, as opposed to our classifying the dog as a nuisance. I don't know if there's any follow-on in the dog's life, whether it's a nuisance dog or not. Perhaps counsel could help me on that. But I would hate to be labeled something that may or may not be true, just because I wanted to see an outcome that seems to be a quote-unquote no-brainer for any dog that is a young dog. So if there is no other consequence to the dog in later adventures, to the dog being a nuisance dog, then I guess I'd be okay with it. If in fact, if the dog barked excessively or did something else and people all of a sudden turn that into a dangerous dog situation because of prior events, I would feel pretty badly about that. So that's my take on it.
Madam Chair, can I respond to that?
Yes, please do, Attorney Winter.
So in terms of sort of grander consequences, I'm not aware of anything. There isn't the equivalent of sort of a background check on a dog or a quarry for a dog. But in terms of practical consequences, obviously there's sort of a stigma that comes with that. But also there's a record that we maintain here. And so if another complaint were ever to be filed, we would discover that in our files, this board issued an order that the dog was a nuisance or dangerous, or we would have that file. And you would have to hold a new public hearing and reach a new decision based on the facts of that case. But I have no doubt the board would be mindful of the history in which that case arose. So I don't think there are any consequences beyond that. And I can't speak to things like insurance coverage or what other kinds of consequences might be out there in the universe. I don't have any knowledge of that. And then the last thing I wanted to say is I didn't mean to, and I hope nobody understood me this way, to suggest that a finding should be a means to an end. you make a finding based on the evidence in front of you. And so I just want to be clear that I only highlighted it just so we could discuss it. And I wasn't suggesting anything otherwise.
And it's been seconded. Any other discussion? Nope. Vice Chair Cavey?
Yes.
And I vote yes as well. All right.
So the next phase is the orders. So you can go in either order you want to. For a nuisance dog, you can fashion any remedy the board thinks is appropriate to address the behavior that led you to find the dog a nuisance. For a dangerous dog, you have the list right in front of you, and there are 7, and the statute requires you to pick 1 or more of the 7. Strangely, it doesn't say you can only pick from the 7, but it says you have to pick 1 or more from the 7. So in theory, if you had another idea, and I think I heard some suggested, I made a few notes on some suggestions that I heard. Even if it's not on the list, I think you should raise it. But you certainly have to pick 1 or more on the list. You have it in front of you, but I'm happy to summarize. Number 1 is humanely restrained. 2 is confined to the premises. 3 is if the dog is removed from the premises, that it be securely and humanely muzzled. 4 is proof of insurance. 5 is the information. That's the paragraph that mentions the microchip. 6 is that the dogs or dog be altered if they haven't been already, and there's no medical reason not to. And then 7, of course, is humanely euthanized. So you can pick for a dangerous dog from that list. And it's 1 or more, so you can pick 3, you can pick 4, you can pick 5. It's up to the board to decide what's the appropriate remedy. And I think we heard some testimony as to number 2, just based on living arrangements, that there may be some obstacles to 2. But I'll let you weigh those.
Madam Chairperson, just for your information, it's in the materials. Both dogs are microchipped, if that's a consideration.
And altered?
I'm sorry?
And altered as well?
Yes, and altered.
Yes.
So I'd like to make a motion with regard to Dakota, just because I think the case might be a little bit simpler. Given that Dakota's been found a nuisance dog by this body, I move that the owner, 1, adhere to not walking this dog with any other dogs. 2, have the dog trained, provide to the town evidence of its having been trained with reports from the dog trainer on the success of that training. 3, that Dakota I'm sorry, I'm sort of searching for the right words. I apologize for this. But that she be seen by a animal behavioralist or a psychiatrist to help the dog with socialization and with anxiety. Additionally, that the dog be when not at home, humanely restrained at all times. Looking through some of these requirements. Okay, and that the since the dog was microchipped, this should be fine, but that the owner of the dog provide to the licensing authority, or in this case, the animal control officer, information by which the dog may be identified throughout its lifetime, including but not limited to photos, videos, veterinary examination, tattooing, and microchip implantation, or combination of those. So those are my recommendations. Yeah. So it's the one of the recommendations for a dangerous dog, but I think it's fitting here as well. Just that the owner, this would be item number 5. Basically, provide a means by which we can track the dog.
You said restrained, being
humanely restrained. Yeah. So that is item number 1, that the dog be humanely restrained when not in its house, or not in its premises, right? So if you're walking the dog, it has to be humanely restrained at all times.
Mm-hmm.
Okay.
Question for town council. Mr. Winter, I'm sorry,
Yes,
Madam Chairperson.
please, yes.
Attorney Winter, I just several issues. So on number 7, which I think is the microchipping, I think it should be important that the board be clear which ones they are invoking, and not just and/or. I think we're going to walk down a little bit of a wormhole with the issue of the behavioral and the training. I think the two necessarily go hand in hand, and maybe it should be a recommendation that the behavioral component with the psych eval happen first, and maybe tandem that with the number of trainings the dog is required, because if it's written so vaguely, I think the dog would require training in perpetuity. It would never terminate. So there would have to be some identified number of trainings, or for a period of time,
Madam
I would
Chair.
suggest, just so there's clarity. And then the point of the psychological evaluation would be what? What if it comes back and says the dog is okay? But what if it comes back and says the dog is not okay? Maybe suggestively, the behavioral sort of works in conjunction with the degree of training, if that makes sense.
It does. Attorney Winter?
Yeah, I just wanted to add a comment. So what you're doing now, the board, is voting essentially not only on a disposition, but to instruct me to write a written decision. And so rather than get sort of down in the weeds on all of those things, I'm going to capture what I believe is the intent of the board's past motion, and I'm going to reduce it to a full form written decision. And in that process, I will flesh out a lot of these questions and concerns, because I want it to work. I want it to be a functioning decision for you to consider and then adopt as your own if you see fit to, and to make any changes as you see fit to. And so I'm going to address a lot of these things as we go along. But I, of course, need to know what the will of the board is. And so I hear council's comments, and those kind of refinements will get baked in as we go along. But I need to know what direction the board wants the decision to go in. And so charging me with that is the first step. And the second step, when you get that written decision, is to adopt it as the board's order. So this motion is not going to be the final order of the board. The next stage will be.
So would it, oh, sorry. Would it help with clarifying the items that Vice Chair Cavey mentioned, like Roman numeral 1, 2, and then go to not 7? You know, would that be more helpful for you, or do you understand when Vice Chair Cavey was reading off his recommendations, it was pretty clear? And concise.
I believe I understand, but to the extent that I don't capture it accurately, you're going to get another chance when you see the written version of this. And so if I, just using number 5 as an example, if I list out these categories and the board says, no, that's not consistent, or we don't need all of those, we need one of them, you're going to fix it. You're going to revise that. And so before your signatures are affixed to this and before you vote it and adopt it as your order, that polish will be applied.
All right.
With regard to training, I'll just the extent that it's, you perhaps understand my thinking in this, is that these dogs should all be able to be recalled by voice command. They should be able to sit. They should understand some version of what, stop or no. They should be able to do this in a one-on-one situation, a situation where there are other dogs, a situation where there are human beings, where there's noise and distractions, and they should be able to do that without any real failures. In this case, they should be able to successfully be recalled, sit, and understand some sort of a no or stop command in any sort of real world scenario where there are other dogs and there are people. They don't have to be trained to the point where they're ready to be in the circus, but they do need to be able to fulfill sort of these simple social requirements.
So my question, council did mention what should come first, the behaviorist or the dog training. So will you address that in your order to us as well?
I will make a suggestion.
Sure.
And in the written decision, I'll make a suggestion. Again, just with an eye towards functionality and practicality. They're going to have to comply, theoretically, with this order, and so we want it to actually be practical. And so I'll work on that, and if I don't get it right, you'll have a chance to revisit it.
Just one other thing, actually, being able to walk without pulling is also a critical issue in this. These are all sort of being able to be walked without pulling somebody, healing essentially, is also going to be that's on my mind as well. She should be able to control them, these dogs, without any issue. They should stand right by her side and walk peacefully, without fear of others, without conflict with others. And these are all. I don't think you'll find a dog trainer who doesn't essentially focus on these. So I don't think that we're going to have a problem finding somebody who can accomplish this. So that's the motion.
Thank you. From my perspective, I think you captured the essence of sort of being under control with a voice and not needing to have a choke collar and all the other things that one might need to have in order to be a good dog.
Yeah.
Right.
Motion's on the table. It has been seconded. Any further discussion on the motion? Okay. On the vote.
Aye.
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 And I vote aye as well. Thank you very much. Anything else, Attorney Winter, based on the operation?
Not as to Dakota, but you'll need to reach a disposition on Maverick now. So you determined that Maverick was dangerous, and so again, the statute prescribes a list of remedies that you can impose, either one or more. And so the same process you just went through for Dakota, you should consider for Maverick.
Madam Chairman?
Yes, Mr. Carrera.
You want a motion?
Yes, please, Mr. Carrera.
I think we should, my motion would be to revert to number 7, that the dog be humanly euthanized.
Is there any discussion? The motion has been seconded. Any discussion?
Well, you sure? I'll definitely step in. I think I see the justification for it. The injuries to Ms. Wilson. I know that she had difficulty testifying, and but even without her testimony, just viewing the pictures and the video that we've seen was extreme, and everything everyone has said has been entirely true. If this event had happened where a child had provoked it, either accidentally, intentionally, or had done what Ms. Wilson had done, which is simply walk towards it, then the consequences would have likely have been fatal. And so I see the justification for the recommendation. I'm going to defer to the will of the full board, and I trust the process enough to follow this through. But I do feel that that some of the other options here would be viable in this case. I think many of the things we've already talked about with proper training, behavioralist review, having the dog not walk together with other dogs, and additionally having it humanely restrained, confined to the premises, and that the owner provide proof of insurance, not less than $100,000, as well as muzzling the dog at all times when it's not on the premises, would provide a adequately safe situation for this dog. The main concern I've had, and I mean certainly no disrespect, but the owner's lack of familiarity with dogs that pose a threat concerns me more than the dogs themselves. And so I'm concerned that I don't feel 100% positive. I'm not feeling very confident that these orders will be followed through, and that concerns me. But this case is not about the owner; it's about the dogs, and I think that a reasonable person could get these dogs into a position where they could be managed. So that's my view. I think euthanization, is more extreme than I'm willing to go on this particular case. However, as I mentioned, I respect very much the other members of this board and your thought process on this, and I additionally respect the recommendation of our animal control officer and the work that she's done as well. So I can see where you're coming from. Thank you.
Thank you very much. And I have no other comments.
I do.
Okay. Mr. Gito.
I think if the officer who was there didn't do what he had done and wasn't able to do that we would have had a much more serious problem than we're faced with at the present time. I don't think that there was any way that dog was going to get off that person. And I say that not only that the dog was tased once and went away, but also came back and did the same thing again. Looking at that video was pretty horrific as far as I'm concerned. That's the kind of a thing that a loose dog in the great state of Maine would do when they were going after a deer. And there was no stopping a dog in that situation. And I think that's kind of important to keep in mind.
Madam Chairman,
I agree with Mr. Gito's statement. I wasn't going to say anything, but he hits the nail on the head. We're just lucky that the officer did get that dog off, because usually what happens is the owner becomes the recipient of the biting, because once they pull it away from something, it'll turn on them. So she could have had 2 dogs on her after the other person got bit. So I don't think there's any help for this dog. It should have been given prior. They need to be nurtured. And I've said it before, even the officer said it, once they get a taste of blood, that's it.
And I agree with you, Mr. Carrera, and you, Mr. Gito, without rehashing all of the evidence again. So on the motion that's on the table, on the vote at this point in time, Mr. Gito?
Yes.
Vice Chair Cavey?
Respectfully, no. Sorry, that was my mic wasn't on, but respectfully, no.
Mr. Carrera?
Yes.
And I vote yes as well. Thank you. I'm sorry, what was? He said respectfully no.
So the next step, Madam Chair, is that I will draft a decision that reflects the votes taken here tonight, the evidence, the procedures, et cetera, and I'll put that before you for your next available meeting when you can take it up. So we can talk about that online in terms of scheduling, but at this point, it's on me to prepare that and to collect all this and return it to you.
So, but from the time that you're drafting the document and we meet again, what happens to the dog, the care, custody, and control of the
So
dogs?
the current
2
arrangements,
dogs.
the current arrangements should continue. And by the way, the order is not immediately effective. So there's a 10-day appeal period. And so once, if and when we're in court, the situation can change. We have rights to ask the court to take action and so on and so forth. But until that order issues, they don't have a right to appeal, which means we can't be in court. And so I would respectfully suggest that we maintain the status quo during the interim. And obviously, counsel and his client need to discuss what they want to do once they've received the decision. They need that to make their decisions as well.
Thank you very much for that.
Do we need to make that motion, or is it just implicit?
My preference is that nothing be implicit. And so if that's the will of the board, then I would make it explicit.
Yeah.
Then until the order is finalized and the appeal period ceases, at least until that time, then the dogs will remain in the pound.
Is that for both dogs?
Oh, no.
So just let's be
should be
precise.
For Maverick.
For Maverick, okay.
And I don't know how we should handle Dakota, because that dog needs to be trained. Maybe we need to keep the dog in the pound until we have proof that that dog is in training. I don't know. I mean, maybe another mind would have a different view of that. But until such time as we have discussed that, I'll put that both dogs should be there, and somebody can modify that motion to deal with Dakota differently.
I'll second your motion.
Discussion. My concern is, what's a reasonable amount of time? Because the owner and counsel has not received anything in writing from us. All they've heard is our discussion. And I would think that once they get something in writing that's tangible, then they can take action. Is that a real concern? Is my concern real? And if it's yes, what's a reasonable amount of time that you should get this to us? We should get it back on our agenda so they would have, the owner would have, and council would have something.
So for our process, we'll proceed forthwith. So at your next available meeting, I'll have that decision ready for you to vote. From the owner's perspective, kind of twofold. One, the order's not effective until you sign it and issue it. And so there really isn't any, order in effect now. That being said, with respect to Dakota, there's never going to be an order that Dakota be impounded, until some date certain. So even when your order issues, they just need to comply with it or appeal it. But there's no component of it that would require that Dakota be kept in the kennel during any, pending period.
That's a good point.
So if that's the case, it wouldn't sort of logically make any sense to impound the dog, because that's not what's going to happen when the order issues in any event. So you may want to just sort of take that into consideration with respect to Dakota. And right now, we've been operating under an agreement with council. I think we said it was $20 a day for both dogs. So I assume if you do one dog, $10 a day. And the order, when it issues for Maverick, is substantially different. And so I would think you would take a different tact in that case. There's sort of a quirk in the statute in that it doesn't talk about the interim period, a temporary order until you reach a final disposition. Now, I can address that if and when we're ever in court, but until that period, you could say that the dog be impounded, that the dog be muzzled and restrained until such time as the order becomes final and is carried out. So you could handle that in your proceedings that way, and we can reflect that in the written version of it too. But the statute's sort of silent in that interim period.
So in layman's terms, Dakota can go home.
Right.
Huh?
That's the board's
No?
decision.
Okay.
Not mine.
I don't see it that way.
Okay. Please.
I see it
Mr. Kara.
until we get the brief and sign that, then the dog can be released.
Okay.
Because
I can agree
right
with that.
now it was at a hearing. The dog is still under the suspect of what we had the hearing on. That just because the hearing closed, it closes when we sign that document. I mean, she could sell the dog, move it to another state, do whatever. I mean, and then anything that we say is just no good. Nothing's going to follow it. Nothing will be attached to it. It's all just verbal.
True.
We didn't put the dog there. We didn't do it. We had to protect the citizens, and I still think until Miss Geller is moving out of the town to wherever she's going, she's still under what we say is what we say. I don't think we should release the dog.
Thank you, Mr. Carrara. Vice Chair Cavey.
So this is actually just a question for Mr. Winter. And I asked this, I know you say the statute's silent on a lot of these things. I respect that, but you've also probably seen something like this in other communities, or there's likelihood that you have. And the time period that we're talking about would really, to me, would normally sort of sensibly fall into the jurisdiction of whoever was assuring compliance with the order. And they wanted to just make sure that we said the dog has to be trained, and no one's going to respond, well, you never told me when I had to do it by, so maybe sometime in the next 5 or 6 years, I'll see if I can get around to it, right? Instead, I'm sure that there's some expectation within the compliance of the order that it happened within some sort of a reasonable time. Am I right in that? Is there sort of generally understood principles on how that's applied?
More so than that, I'm going to make that explicit in the draft order. Because in order to enforce an order, you need to know when someone's violated it.
Yeah.
And if there isn't a time period for compliance, we're never going to know if they complied or not, for the reasons you just stated. And so on the front end, we issue the decision, there's a 10-day appeal period. So that's going to happen very quickly. We're talking about 2 to 3 weeks. On the other end, when the appeal is final, or if there's no appeal, we need to be able to review that order and know if there's been compliance or not. So the clearer the order, the easier that job's going to be.
So with regard to the training that we're talking about, this level of training usually requires the dog to be sort of in-house somewhere to have this level of training, 2 to 3 weeks of training where the dog would more or less be with a professional trainer caring for the dog and training them. I don't believe we could have that occur at the same time the dog is required to be continually quarantined in our pound. Logistically, I don't see how we could have the dog adequately trained and also evaluated by any sort of behavior expert while it was continued to be in a place where it was sort of abnormally stressed and that is not really conducive to the kind of training we want to actually see accomplished. So I wouldn't want, once the appeals period's over, one way or the other, I would love to, I think it'd be appropriate to see, at least in Dakota's case, that she be returned, that she be able to, we have a number of requirements, including that the dog be restrained at all times, and that I think that will then allow for these other requirements to take effect. I don't think we can have it both ways, where the dog's both confined and also socialized. Those are antithetical environments. So I would want to see that within some time frame after the appeal, the dog be returned, so that they can begin this process of compliance.
And I think I mentioned this earlier. Until you sign and adopt that written decision, there is no order in effect. And so that would be the 10-day clock. And so it would be effective on the expiration of that 10 days. And that would be the trigger point.
Perfect.
Would you say that again? I mean, we're talking, my motion was, what are we going to do between now and when we make a decision? Isn't that right? And so are we, I don't know what you said in relation to that. I thought that Steve was saying, well, we can't, we have to allow the dog to be trained, but I didn't know if that's going to happen between now and next week or the week after. You asked us to be explicit in terms of, well, I think we should be explicit also in terms of what we're going to do with the dog in the interim period. And so it's clear for me in terms of Maverick, where Maverick should be, and not knowing anything better, we had caused the dog to be a nuisance dog, and that which is different from a dog picked up on the street and then just released back to his owner. So I was going until the time that we finally made a decision on that, at least, and maybe until the appeal period is over or not. So I'm not sure where we are. Could you tell me? Could Steve tell me? Could anyone tell me what that has just transpired?
Yeah, sure. I mean, and I might be misunderstanding your question, so I apologize if I am. But so, Mr. Weiner, please tell me if I'm missing something here. But we have a time period where there's an appeal process, roughly 10 days. I don't know if that's business days or actual days, weekdays.
10 days. It doesn't make any difference. We can figure that out.
Well, it's difference between 2 weeks and a week and a half, right? So something like that. So 10 days. During that period, there may be an appeal. If there's an appeal, I imagine that might take some additional time until that process has been resolved. But in the meantime, during that entire span of time, when there are appeals, the dogs will remain where they currently are. And so nothing changes. Everything's exactly the way it is.
That's what I was trying to find out.
Yeah.
Okay.
Once that period ends, then we start this next phase, which depending on the outcome of the appeals process, may include the requirement that training be initiated.
Right. That was what my motion was. I just didn't know if it got changed. Thank you.
No problem.
And I think I mentioned this earlier, but just a nuance. If there is an appeal, it'll be up to the court to decide that disposition. The jurisdiction of this board will now be vested in the court. And so there's a process contemplated by the statute. So we can express, our will up into that point, and then it'll be up to the court.
Is there any further business on the hearing on this?
Aye.
For adjournment?
No.
Oh.
For the vote on the motion.
Okay, on the motion you said aye. Vice Chair Cavey?
The motion is simply to have the dog be in quarantine until the end of the appeals process?
Yes.
Aye.
Aye.
And I vote yes as well.
I think that's the last piece of business we had to attend to, and I'll get to work on the decision.
Thank you very much, Attorney Winter. Is there a motion to adjourn? Oh, yes.
The term quarantined would use, and that's very specific when it comes to the dog officer. So if the order says quarantine, then it's analogous to the 10-day quarantine period that they initially experienced, which would.
You want to use impound?
Well, and the intent, I believe, I don't mean to put words in anyone's mouth, was to maintain the status quo, which is that the dog remain kenneled. Is that correct?
Yes.
That was my understanding. I'm not looking for anything beyond what is
Use the
currently.
word quarantine, and that is very specific.
Yeah, apologies.
Okay,
apologies.
Right.
Second.
All in favor?
Aye.
Aye.
And I vote aye as well. Good night, everyone. Thank you.
Thank you so much.